This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to explain why it is never appropriate to complain after you win a case, and why it is chutzpah, unmitigated gall, to first plead guilty to fraud, receive probation, and then appeal the conditions of probation. Raimundo Gonzalez appealed the condition of probation imposed after he pled no contest to one felony count of insurance fraud. Specifically, when Gonzalez was placed on probation by the trial court, one of the conditions of probation permitted searches of computers and handheld electronic and cellular devices. No objection was raised to the condition when it was announced. In People v. Raimundo Gonzalez, Gonzalez sought removal of the search of electronics equipment condition. In the claim for which he pled guilty, or no contest, the defendant alleged he was injured on September 5, 2013 after pulling irrigation lines when the tire of a tractor hit him on the right foot, causing him to fall. The injury was documented and defendant saw a doctor at the end of the day. A workers' compensation claim form was also completed by Gonzalez and his employer's safety officer. In March of 2016, Gonzalez was examined by Dr. Stephen Choi regarding his ongoing claim. Defendant told Choi he had not suffered any prior injuries, and following a clinical exam, Choi was unable to make any specific findings, but eventually concluded that 75% of the injury resulted from the incident of 2013. A new evaluation was completed in February of 2018, 5 years after the alleged accident, after surveillance footage from November 2013, April 2015, June 2015, and September 2015 was considered. Choi asked for reevaluation after seeing the footage, which showed defendant moving as if he was injury-free. Choi observed defendant working hard, picking up things from the ground and bending and twisting his body without trouble. Choi concluded these movements should not have been possible if he truly had lower back and shoulder pain. This new evaluation determined defendant did not have any impairment or disability and did not require future medical care. A further investigation revealed defendant filed various claims for injuries while employed with other companies between 2001 and 2011. Defendant claimed he was not able to stand or walk for long periods of time and could not lift anything or bend. Defendant further stated he had never filed a workers' compensation injury claim and never suffered an on-the-job injury. All these statements were false and were in direct conflict with what was depicted in the video footage. Gonzalez was eventually charged with 3 counts of insurance fraud and 1 count of perjury, and he entered a plea of no contest on count 1, and the other 3 counts were dismissed under the plea agreement. And on August 3, 2022, many years after his fraudulent claim, the trial court sentenced the defendant to probation following the plea. A condition of probation which was imposed without discussion or objection was an electronic search condition requiring the defendant to submit to a search of his electronic devices with or without a warrant. Now, the Court of Appeals, discussing the issues, noted that a trial court may impose and require any or all of the terms of imprisonment, fine, or conditions as it determines are fitting and appropriate. A condition of probation will not be held invalid unless it, 1, has no relationship to the crime of which the offender was convicted, 2, relates to conduct which is not in itself criminal, and 3, requires or forbids conduct which is not reasonably related to future criminality. Because defendant's trial court did not object, Gonzalez claimed ineffective assistance of counsel. To establish ineffective assistance of counsel, a defendant like Gonzalez must show 1. Counsel's representation fell below an objective standard of reasonableness under prevailing professional norms, and 2. Counsel's deficient performance was prejudicial. Unless a defendant establishes the contrary, the court will presume that counsel's performance fell within the wide range of professional competence and that counsel's actions and inactions can be explained as a matter of sound trial strategy. The court's review of the record revealed that the defendant asked the court to be allowed to travel to Mexico during his probation to visit his grandchildren, who he apparently visited often. The court allowed such travel as long as permission was obtained from probation first. It is not unreasonable, therefore, to conclude evidence of travel not cleared by probation could be found on a computer or other electronic or cellular device. The possible reasons discussed provide a satisfactory explanation for trial court's decision not to object. The type of evidence that might be found on a computer or other electronic device would support the condition. Defendant's intent to travel outside the jurisdiction while on probation could also be monitored through these devices. If probation had reason to suspect he traveled or was planning to travel without obtaining permission first. Moreover, the decision not to object to the electronic device's condition could be related to the decision by the trial court not to impose a jail sentence, which it probably should have since he was a serial workers' compensation fraudster. The facts establish that Mr. Gonzalez committed workers' compensation fraud against various employers, including the last one, which resulted in his conviction. Because investigators acquired video providing he had lied about his condition and work history, when the doctor saw the video, he was offended and cut him off. To complain about the terms of probation and take up the time, not only of a trial court, but of a court of appeals, was unmitigated gall, chutzpah, and should have resulted in more than a loss of the appeal, but showed a violation of probation sufficient to cause him to start serving some jail time. But again, he got away with it, and he is probably making another workers' compensation claim against some other employer. This video was adapted from my blog, Zalma on Insurance, which is available free to anyone who clicks on the URL zalma.com/blog. If you found the video to be interesting or useful to you, please tell your friends and colleagues about the blog and the videos and let them also subscribe. And if you wish further detail on insurance, insurance law, insurance fraud, and insurance claims, please consider for a very small fee to subscribe to my Substack publication or to Excellence in Claims Handling at locals.com. Thank you for your attention.